This case is about a betrayal of trust at the highest levels, betrayal of trust as well as breaches of fiduciary duty owed by Ms. Burgess to Mr. Upchurch. Those breaches include material misrepresentations, theft, many millions of dollars worth of, theft out of his bank account, buying property.
She's my attorney, so we have a conflict of interest here.
Ryan Upchurch, Blue Moon Entertainment LLC versus Patricia Burgess. Yeah, I think you're going to have circuit come if they can plug it in, and that would be my thought. So now we're ready for Ryan Upchurch versus and Blue Moon versus Patricia Burgess. I think I was told there's some video that's being asked to be played, and we're working on trying to set that up. So
Thank you, Your Honor.
you want to make any sort of opening statement?
Yes, Your Honor. So Cynthia Sherwood and Austin Carell for Ryan Upchurch and Blue Moon. And we filed on March 31st, we filed a complaint and a request for a TRO and temporary injunction. The temporary injunction was granted in April, and we are here today on the temporary injunction hearing, as well as our motion for default.
All right.
So this case is about a betrayal of trust at the highest levels, betrayal of trust as well as breaches of fiduciary duty owed by Ms. Burgess to Mr. Upchurch. Those breaches include material misrepresentations, theft of many millions of dollars worth of, theft out of his bank account, buying property.
Hold on just
Yes, Your Honor.
She's trying to whisper to me. I
Okay.
don't hear her
I
whispering
can't
very
do
well.
that.
Our circuit court runs our big TV, and she's got to get over here where the court reporter is in order to make some. So just bear with us for a second.
Yes, Your Honor. You said bear with you. Are you ready?
Bear with us. We're going to come back to you in just a moment as soon as we can get this adjusted. So, is it audio or video?
Both. Yeah.
This is the Patty Lynn video.
This is, Your Honor, I should have done this when I first stood up, but this is a courtesy copy of the court. There was two filings made this morning, one of which is that video, and then the second is a declaration with some deeds.
Right.
Attached.
Well, this is a hearing on the extension or the request for extension of injunctive relief that your client, Mr. Upchurch, has filed against his mother, Ms. Burgess,
Yes, Your Honor.
alleging that she has misappropriated funds that belong to Mr. Upchurch as his business manager, that she has abused that position and misappropriated funds, if I understand correctly. And as a result of that, if I recall reading the file, that he alleges that she has purchased real property in her name using his funds. Is that?
Yes, Your Honor. So the property at issue, there's 7 houses in total. We've got the deeds.
7 houses.
7 houses in total. The first house is titled, at least as far as the deed that we have, is one house titled in Patricia Upchurch's name. And if you court would follow along with me on the declaration that I filed today, if you go to the notice of filing, page 2 is a declaration, and we can walk through the property. It's on the first page of the declaration.
All right.
So the first piece of property is 1240 Road. That property, as far as we can ascertain, the deed is in Austin Upchurch and Patricia Burgess's name. Patricia Burgess is Mr. Upchurch's mother and former business manager, and Austin is his brother.
All right.
And that particular house, Mr. Upchurch did intend to buy a house to help his brother. The only surprise to Mr. Upchurch was that his name was not also on the deed. Then you go to exhibit number 2 or number 2 listed on that document, and it is Pleasant View, Tennessee. That was a house purchased, and titled in. So the next three houses, exhibits 2, 3, and 4. You see that, Your Honor, on the declaration? All three of those houses are titled in the name of Blue Moon LLC. Blue Moon LLC was an entity created, as Ms. Burgess even admits, and we'll look at an email here in a moment, to protect Mr. Upchurch. It is the successor to the original entity, Upchurch Enterprises, where all of Mr. Upchurch's earnings, and we're talking millions and millions of dollars, were funneled into Upchurch Enterprises account. In 2017, Ms. Burgess came along and started operating as Mr. Upchurch's business manager. She'd always been around, but she took on a more active role. Then at some point in time, either she decided or someone decided that Blue Moon LLC would be created. And in that declaration that you've got, you'll see the very last page of that. It's a February 5th email from Ms. Burgess telling me, after this lawsuit is about to commence, but she told me, I formed Blue Moon to protect him legally as a management company. So this was Mr. Upchurch's understanding that this was his company. It was formed for his protection. But then in her very next paragraph, she says, I'm leaving Tennessee and going to try to get someone to help me sell one of the Blue Moon homes to pay for security for me and my other sons. So Blue Moon was created as every bit of Mr. Upchurch's touring income, record sales, copyright, royalties went into, instead of going into Upchurch Enterprises, went into Blue Moon. So I got off script a little bit on the houses because that's why these houses 2, 3, and 4, Highway 41, North Pool Street, and Clay Lake Road are titled in Blue Moon. You'll see in Mr. Upchurch's affidavit, he engaged the realtor. He picked out the house. He engaged the realtor, and he says, my mother's going to handle everything. This is business manager. Those houses are titled in Blue Moon LLC. The next two houses, well, the Exhibit 5, North Main Street, Mr. Upchurch was aware at some point after the fact that Ms. Burgess had purchased with Blue Moon's phone this North Main Street. He talks about this in his affidavit, but thought it was also titled in Blue Moon. Did not know that it was titled, that house is titled solely in Patricia Burgess's name. The next house, East Elm Street, is listed even though Mr. Upchurch currently has title to that house. As is set out in Mr. Upchurch's affidavit, which Ms. Burgess purchased on April 28th, 2022 in her own name. She purchased April 28th, 2022. On October 14th, 2022, she transferred that property to a woman by the name of May. May was her assistant, and that house was paid for with $500,000 cash out of Blue Moon funds. All of these homes were purchased with Blue Moon funds. Mr. Upchurch did not know about this property until the realtor told him about it and told him about all of these houses. This is how he found out. So he contacted Miss May. That house was immediately transferred back to Mr. Upchurch because I would suggest that says Miss May knew there was something going on that she did not want to be involved in. The next house, Exhibit 7. So the Exhibit 7 is in Clarksville. That house was the Main Street house at number 5 was sold, and this property was purchased, and that house is titled in Patricia Burgess's name as well. So you have number 1 in Austin, Upchurch and Patricia Burgess, and then numbers 5, 6, and 7 just in Patricia Burgess. Well, not 6 anymore because Mr. Upchurch got that back. So 5 and 7 in Patricia Burgess, and 2, 3, and 4 are in Blue Moon. And this lawsuit seeks a declaratory judgment for the ownership of Blue Moon. Mr. Upchurch is putting all of his funds into this account, thinks, as he says in his affidavit, that Ms. Burgess is paying all the fees and expenses, everything that he needs to be responsible for, including the payments on these homes. And then thinks at the end of the period, she's telling him what he's got left, and she's writing him a check supposedly for whatever he's got left out of the Blue Moon funds. Also in the affidavit, you'll note that Mr. Upchurch says he paid for all of the upkeep. For all of these Blue Moon homes, he's paying every cent for the upkeep. He also notes in his affidavit that none of the taxes were paid. None of the taxes were paid for these properties until Mr. Upchurch learned of all of this at the end of the last year, and he's gone and caught the property taxes up on those properties. He's the one who purchased them. The video that we can show is Miss Burgess admitting. She's now stating that she in some of the emails that she owns Blue Moon. Blue Moon is hers. The Blue Moon assets are hers. She had no income. All of this money belonged to Ryan Upchurch. And what this video is Miss Burgess making an online video and stating, Ryan Upchurch bought us everything. He bought my house. He bought his brother a house. He bought his best friend a house. His best friend lives in a Blue Moon house. Mr. Upchurch may have bought homes for people to live in, but he most certainly was not buying $500,000 homes. He did not, with the Blue Moon, he knew about those and he thought those were his. He thought Blue Moon was his. So saying that he bought his best friend a house, yeah, sure, his best friend lives in a house, but that house is Claylick. That's the one, that's actually $799,000 house that's on this property. And then Exhibit 2 is that's where Mr. Upchurch's security guard lives. So that, I think, Your Honor, gives the landscape. Is there another question you have about background?
All right. Obviously, this is a hearing for the extension of the temporary restraining order that was issued. And do you want to put on any proof?
We want to, Your Honor, rest on the affidavits, and I want to just, if I can, we can just walk through the affidavits. But we have the affidavits. We can go ahead and take. Well, let me just walk through the outline. But the affidavits, they are lengthy. That's the affidavit of Ryan Upchurch and the affidavit of Brandon Luce, and they walk through in painstaking detail how this fraud was carried out.
Before we do that, let me address Ms. Burgess and find out where we are. You also have a motion for default judgment.
Yes, Your Honor. Should we be heard on that first?
Seems like that might be the appropriate thing to do, but.
Yes, Your Honor. So we filed a motion for default judgment. The complaint was filed on April 17th, 2023. Ms. Burgess was served with a copy that was served with the complaint on, as the attachment says, on April 17th. Ms. Burgess has yet to file any answer with the clerk's office. On Monday, 2 days before this hearing, one business day before this hearing, she sent an email to my office with responses, numbered responses. That answer has not been filed. That's not done pursuant to the rules. And I would say that's not enough to save Ms. Burgess from a default, because I don't have a copy of this case, Your Honor, simply because I didn't realize she was going to even be filing an answer, because she did file an answer for that email we got on Monday. There's a case.
For the record, the court file does not contain any such answer. I don't see it in here.
We double checked too, and there was nothing filed with the court. The case Conserve Equipment Leasing LLC versus Schubert Enters LLC. That's a Tennessee Court of Appeals case. The citation is 2023 10 at Lexus 39. It was filed February 3rd, 2023. And in that case, you had a defendant who had failed to answer until about 3 hours after the default judgment hearing. So after the default judgment was granted, he filed an answer 3 hours later. The trial court refused to set it aside. The Conserve court overturned that simply because the trial court didn't make findings of record. But what the Conserve court says, I think, is very instructive. It walks through what you have to do in face of a motion for a default judgment. And it talks at length about this case, Pash Industries LLC versus Wallace Hardware Company, Inc. And that's a 2003 10 at Lexus 802. In that case, the Pash case, the defendant in that case filed an answer, served it appropriately 18 days before the default judgment hearing. It was, the default judgment had not yet been granted. But the trial court entered the default anyway, said that the belated filing of an answer is not an adequate response to a motion for default. And here we don't even have that. There must be some application to the court for relief from failure to timely file an answer. The language of Rule 5501 makes it clear that a judge, in the exercise of sound discretion, may enter a default judgment against a party who has failed to plead or otherwise defend in accordance with these rules, as long as proper notice of the hearing is given, and under the rules, an extension of time with which to file an already overdue response is available in discretion of the trial court for good cause shown and upon a showing of excusable neglect. In that case, the defendant failed to file an answer within the time period or otherwise timely defend as required under the rules and made no application for an extension of time to respond to the complaint, but just filed an answer 18 days before the hearing. Here, we don't even have that, Your Honor. Mr. Upchurch has filed a lengthy complaint, filed declarations, filed a motion for request for a TRO. And as we sit here today, Ms. Burgess has responded to nothing that he's filed. There's no answer filed. There's no answer. Whatever the email that we received Monday is months late and still nothing is before the court. So we think under conserve and pass that Mr. Upchurch's motion for default should be granted.
All right, Ms. Burgess. First, I want you to understand that what I'm considering now is the plaintiff's motion for default judgment,
Right.
that they're alleging I should grant them a default judgment based upon the fact that you have not yet filed an answer with the clerk's office.
Absolutely. I understand that. Totally. She's my attorney. So we have a conflict of interest here. She actually is representing me January the 22nd, 2024 in a case as me as Blue Moon, separate from Ryan as Blue Moon. Now, in this case right here, she's saying Ryan is Blue Moon. But I have filed with the Board of Professional Responsibility. I spoke with them last week and I filed this because she is actually my attorney. They froze my accounts and they're suing me for $25 million, which is not even worth, to keep me from being able to afford attorney. I can't get attorney. Nobody will take my case for more than $25,000 and she's my attorney.
Okay. The motion that is before me is a motion for default because of the fact that you've not filed an answer and contending, with the complaint that's been filed. I understand what you're saying, and that's a different matter from what I'm considering. So what is your intention as far as if you are not able to hire an attorney, are you going to represent yourself in this matter?
Yes.
And why have you not filed an answer?
I did file an answer. I didn't think that I could. I was told, because I don't know anything about law. Hell, I don't even know really anything about our business. We were running kind of a crap show. That was my boyfriend, my lover right there. And that was my son. And I was their secretary. So I did what I was told to do. And I was told that when I called to try to get representation, they're like, honey, this is ridiculous. This is 211 points that you have to answer. You're going to have an attorney. I didn't know I had the option to fill out and do it myself until somebody called me and told me, nobody's telling you this, but you have the right to do this. So I did it at the last minute. I didn't know what to do. But
that has not been filed with the clerk's office. The summons that was served on you, just listen as I tell you this.
Right.
The summons that was filed, served upon you had certain information on it, including the following. You were hereby summoned to defend a civil action against you in the Chancery Court for Cheatham County, Tennessee. Your defense must be made within 30 days from the date of the summons is served upon you. You are directed to file your defense with the clerk of the court and send a copy to the plaintiff's attorney at the address listed below. If you fail to defend this action by the below date, judgment by default may be rendered against you for the relief sought in the complaint.
Okay.
Are you alleging that the reason that you are delaying and you have delayed in filing a response is having to do with the fact that Ms. Sherwood was, in your opinion, your prior attorney and therefore you could not get another attorney?
Yes, sir.
I'm not addressing the issue because of the fact that you would have to file a motion to disqualify Obviously, Ms. Sherwood is a competent attorney who would know what the rules of ethics are. If the Board of Professional Responsibility, advises her that she has a conflict, she'll act accordingly. There is no motion to disqualify her before me. So for that reason, all I can do is to consider whether or not to grant a default judgment.
Yes, sir.
Ms. Sherwood, in the interest of justice, I'm going to grant her 15 days to file an answer to this. I'm going to give you 15 days. You have to go through this complaint, and you're going to have to answer each paragraph, either admit it or deny it. It's just that simple. And you file that with the clerk, and then you send a copy of that to Ms. Sherwood, okay?
Absolutely.
Until Ms. Sherwood removes herself from the case. If that is going to happen, then she is the attorney of record as far as this court is concerned.
Yes, sir.
Now, have a seat, and
Yes, sir.
I'll take up your motion for the extension of the restraining order, Ms. Sherwood.
We've already gone over most of the background, but what Ms. Burgess has done is basically perpetrate a fraud on Mr. Upchurch over the past several years. We don't really know at this point how far back it goes, but we do have express examples of it with respect to the property, the real property that we talked about. Blue Moon was created to protect Mr. Upchurch and the profits of his creative endeavors. We've already seen the email that is part of the evidence that we wanted to submit, that she states and admits that it was created to protect Mr. Upchurch. But yet she's selling the properties. Ms. Burgess has said through the email that you just saw where she's going to sell the Blue Moon property. She also said, if you look at in our memorandum in support of our temporary restraining order, there's an affidavit of Brandon Luce, and it should be the last few pages on that. And there's a March 21st, it's Exhibit 1 to the declaration of Brandon Luce. Last two pages of the...
Exhibit 1 to the declaration of Brandon Luce?
Yes, Your Honor.
All right, I have it.
And it states, I need Rob to move out of the house he is living in. It is the property of Blue Moon. He cannot live there for free. I'm liquidating my company totally. So and then if you go to the Exhibit 2 of the declaration of Brandon Luce, she's talking about Rob is living in her house and that she's going to be listing the property. That is that property that was number 2, Exhibit 2 on the declaration of Cynthia Sherwood. So she's talking about Rob Otera. He's living in a Blue Moon house. So this is highlighted, Your Honor, to show that there's this dispute as to ownership. Mr. Upchurch is sworn in his affidavit. He's spending millions of dollars on property, thinking that it belongs to him, thinking that the company belongs to him. Yet Ms. Upchurch Ms. Burgess has made it clear that she is the one who owns Blue Moon. She's going to liquidate Blue Moon. So that is, we have reason to believe that a lot of the money is gone, or if not all of the money is gone, but we don't know for sure and won't know for sure until discovery is done. But if you look at the declaration, there is a Truist Bank account. They call it a garnishment return. That's Exhibit 7 to the Sherwood Declaration. And it talks about the checking accounts there, and there's essentially no money in any of these checking accounts, $4,200, $100, and negative $1,900. So we don't know where the money is, but we know that there is property out there that this court can protect until we can have a trial on the merits. So with respect to the evidence, you've got like I said, Mr. Upchurch's declaration. And if you just walk through it, Your Honor, he tells a very, sad, tragic tale. I mean, I guess it's not entirely unusual. It looks a little bit like reading, I don't know if you've ever watched those behind the scenes music specials. That's really where it is, where a manager has come along and taken advantage, and oftentimes it is the parent. But if you go, in paragraph 7, he talks about Ms. Burgess becoming his business manager. And at that time, the money was run through Upchurch Enterprises. She was responsible for incorporating Upchurch Enterprises. And then he talks about the early years with Upchurch Enterprises and all of his money going into that. But then if you go over to page 4 in paragraph 31, he says that's where on December 9, 2019, in her role as business manager, Miss Burgess incorporated Blue Moon LLC. Now, while you won't see Miss Burgess listed anywhere specifically, because in the email she denied being his business manager, if you look at Exhibit 1 to Mr. Upchurch's declaration, you have the filings with the Secretary of State, and these aren't numbered, and I apologize, Your Honor, but the document filed on February 15th, 2022, it notes that Patricia Burgess is Ryan Upchurch's business manager. That was filed with the state of Tennessee. Blue Moon, Mr. Upchurch tells you in paragraph 32 of his declaration that Blue Moon is named after one of the songs he wrote. It was to be his corporate entity through which he booked his shows, and that would be the holding company for his touring and merchandise income. And Ms. Burgess essentially admits that in the February 5th email. And she says, this company was created to protect Ryan. Page 5, Mr. Upchurch says, Blue Moon always has been a singer member LLC intended to be owned by him. But as we can see in the emails, Ms. Burgess is now claiming to be the owner, not just of Blue Moon, but all of the millions of dollars worth of properties that were purchased with Mr. Upchurch's money. Mr. Upchurch tells you in paragraph 40, thereafter, all of my earnings from touring and merchandise and sales were made payable to Blue Moon and deposited into Blue Moon's bank account. My income was the sole source of funds deposited into the Blue Moon account. The money that Ms. Burgess was previously putting in Upchurch Enterprises was now diverted, with his knowledge, to the Blue Moon account. All of my business expenses and majority of my personal expenses were paid out of the Blue Moon account. While operating as a business manager and manager of Blue Moon, Ms. Burgess claimed to be paying all of my expenses, and after all those were paid, giving me the remainder of my income earned. I believe she was stealing money from me from the inception, if not before. Paragraph 49, he says, Blue Moon did not and does not have any revenue stream other than my revenue. Blue Moon is not a fee or revenue generating company. I entrusted Ms. Burgess as my agent, power of attorney, and business manager to maintain Blue Moon's books and perform duties beneficial to me as required by her fiduciary duties. Paragraph 51, he purchased Ghost Ranch. He purchased that house on August 21st, 2018. That is the one and only house. This is the one and only house that is actually titled in Mr. Upchurch's name. The other houses that Mr. Upchurch bought, and he says this, he goes through this extensively in his affidavit, but I won't go find the particular paragraph, but he tells you that he bought Clay Lick. He bought Clay Lick for him to live in. That's a $799,000 house that he bought for himself to live in. It's titled in Blue Moon. He let his mother handle the matters with the real estate agent, also believing that he owned Blue Moon. He moved into Clay Lick. He lived there for a bit, had some construction problems with it. And so he moved out and he bought himself North Pool. North Pool is also in Blue Moon's name. That was the house that Mr. Upchurch bought for himself to live in. Eventually, he left North Pool and went back to Clay Lick. And now he's at Ghost Ranch. But all of these houses belong to Mr. Upchurch. If we look at this video, just go ahead and show it to the court.
Play it for Ms. Burgess to make sure she's seen it.
Yeah.
All right, then set it on the podium. Then.
Make sure that it's all. It doesn't have to be that we got all these. This is something that we already read. If one of us ever made it, we would make sure that it's all. It doesn't have to be that we all these. This is something that we already read. And we'll practice understanding. We're all. So he does his work. He is just a very thoroughly good engineer. Being that he was kind of all of them. Because we're all people giving. And it's right into the best. It's one of the first. Very It's deadline for her access to the book.
What that said that he is purchasing homes. The only home titled in Miss Burgess's name is, she said, Brian bought me my house, not 1, 2, 3, 4, 5 houses. And that's going to be a question for the court, whether Main Street, which was titled in Miss Burgess's name, was in fact voluntarily, whether Mr. Upchurch knew that was purchased in Ms. Burgess's name. And what he would testify is and what he has testified to in his declaration is that he did not. The house for the best friend, as I told you, is a Blue Moon house. Blue Moon, North Pool, and Pleasant View are all Blue Moon houses. So
you're asking for, based upon this, the filings that you have, as well as the what you just played for me, but with the declaration of Mr. Upchurch and the other individual, you're asking to extend this order of protection pending a final hearing. Is that correct?
yes, Your Honor.
And in that, you're asking to restrain her from directly or indirectly exercising any power of attorney concerning Brian Upchurch, from using, spending, transferring, dissipating, investing, donating, or otherwise moving any money from or derived from or belonging to Mr. Upchurch or Blue Moon, or funds originating from income, royalties, or revenue resulting from Mr. Upchurch's endeavors, listing, selling, transferring, or otherwise disposing of any property held in the name of Blue Moon LLC or Patricia Burgess, and or purchased with funds from Blue Moon or Ryan Upchurch, including but not limited to 1242. In addition, you're asking that she be enjoined from contacting the tenants or inhabitants of any of those properties and not transferring any of those properties' title until further orders of this court. You're asking she be restrained from selling, transferring, or otherwise disposing of real or personal property purchased with money from or derived from Mr. Upchurch and or Blue Moon, or acting in any capacity of Blue Moon, or conducting any financial business or other legal transactions. It goes on and lists a bunch of more that I'm not going to go into, but essentially you're asking that she be prohibited, according to that restraining order, from taking any action to dispose of any of this real or personal property acquired through Blue Moon, as well as from doing any sort of action that would essentially affect the operation of Mr. Upchurch's business. Is that correct?
Correct. And it all boils down to not dissipating any of his assets, because part of that is correct, Your Honor. Part of what we have in there is about her not accessing any of his royalty accounts. We didn't get a chance to file this with the court. We may be filing a contempt, but we've got where she accessed his royalty account in June multiple times to the tune of $60,000. It's a couple.
So in the month of June, after this was filed in March, she nonetheless exercised.
That is what the document that we've got that shows that she accessed. It went to an email address. It looks like a payment of what is it called, PayPal account. Or somehow this did not. I don't have this printed. I have this in my email, but it's a company by the name of 1RPM. Mr. Upchurch has since brought on financial advisors to make sure this doesn't happen again. So he's got he's actually a business manager who is licensed, bonded, insured, and they discovered this, and they emailed a document from 1RPM showing that since 2020, Ms. Burgess has money to the tune of $690,000 was paid to a PayPal account associated with Ms. Burgess, and $60,000 of that has been since the TRO was entered in this case.
Ms. Burgess, do you understand what this hearing is limited to today is to determine for me to determine whether or not there has been a need for the extension of this restraining order? Do you have anything you want to say about that one issue? I'm giving you time to answer the lawsuit. This is not about the merits of the lawsuit. This is basically Mr. Upchurch through his attorney seeking to keep you from accessing any funds that belong to him or Blue Moon and from disposing of any property pending another hearing.
And may I just address one thing and I'll sit down and let her. I'm Blue Moon's attorney, have been Blue Moon's attorney, and am currently Blue Moon's attorney, but have never I know that you said that will be dealt with elsewhere, but I just want to note that I have never represented Ms. Burgess.
Ms. Burgess, if you'll come to the podium, I need you to tell me if there is a reason why I should not extend this order of protection, this order of restraining order.
Right. And I'm actually totally fine with that. But what they have done is first of all, they are still distributing funds even in my personal account. In my personal account, because back in the day, we were distributing money everywhere. It was a crap show. Like I was getting the allowance, I wasn't getting paid and everything else. But they have frozen my actual personal bank account. Blue Moon has been shut down by the bank. And Brandon has the logins to 1RPM, to Vidia. By the way, he still hasn't fixed that one yet because we did all these things together. And I don't think that they realize the things that they're missing. But they're still, he needs to relog into Vidia. I don't have the logins to Vidia. He needs to take that out of my account. But they want to, I'm okay with stopping everything. I'm not going to try to sell anything. I don't really care. But I share my personal banking account with my high-functioning autistic son, and he gets money. We share an account so that he gets money as well. They have frozen that account. And because they've frozen that account, I've had to...
You're saying your personal account has been frozen by the bank?
By her.
Okay.
The courts.
Well, the restraining order may have been served on the bank, I suppose, but if you have a personal account and that contains monies, which is also containing money that was a disability check for your
No,
autistic.
it's money because I take care, like he's living with his brother because he doesn't like change, so he's still in the ghost ranch. But my son Aaron, that's his account as well. That's his account because I financially give him money.
Where does that money come from?
Selling jewelry, and some of it's from them also. So I understand that, but I just want you to know that they froze that account too. And I'm totally fine with it. They could keep it frozen because now I have a new account. So I support them keeping the restraining order. I don't really care. I'm just trying to make sure my oldest son actually has money.
All right. Well,
but I'm good with that.
That'll be between you and the bank at this point. I'm extending the restraining order pending a further hearing in this case. You have 15 days to file your answer to this complaint, which I urge you to
I am.
Make sure that you do that and get that filed on time.
Yes, sir.
And Ms. Sherwood, is there anything else that needs to be dealt with today then?
I don't think so, Your Honor, other than just a point of clarification. Are you converting the temporary restraining order into a temporary injunction?
Yes. Well, I am converting a temporary restraining order into a permanent restraining order pending, at least permanent pending the final hearing in this case.
Okay. Thank you. Nothing further.
And we will have Ms. Sherwood draw an order, make sure that you have her mailing address. Go ahead. You need to confer with your client.
I apologize.
That's right.
I think he wanted me to clarify.
Mark that as, yeah, that needs to be marked as an exhibit. Yeah. Yes.
Just wanted to clarify for the record that his brother Aaron, it's not autistic, and also that Aaron currently lives with him. But I know the court's already ruled, so thank you, Your Honor.
All right. That being the case, then that concludes our business for today, and we are adjourned. So.
Thank you, Your Honor.
All rise. Clerk Court is down.
Will you hand me my screen box?